push the button. Yeah, thank you. We start with the attendees. You, of course, by now know the tribunal. Mr. Dreimer on my left, Professor Sands on my right, the secretary of the tribunal, Ms. Mingus, in that there in the back, and the assistant of the tribunal next to her, Dr. Lange. Now, can I turn the floor to the claimants? Mr. Toshingham, you want to introduce who's here on behalf of the claimants?
Thank you very much, Madam President. So my name is Mark Tushingham, counsel of 20 Essex, Mr. Neil Newing of signature, Mr. Pietro Grassi of signature, Mr. Colin Greck of signature, Mr. Alexander Fraser of discovery, and Mr. Ben Faro of signature.
Thank you. Can I then turn to the respondent, Mr. Anway? Do I give you the floor?
Yes, thank you. Stephen Anway from Squire Patton Boggs, and with your lead, Madam President, I'll have my team members introduce themselves.
Good morning, Madam President, members of the tribunal. I'm Rostislav Pekac from Squire Patton Boggs.
Good morning, I'm Douglas Palau from Squire Patton Boggs.
Good morning, I'm Tatiana Prokopova, Squire Patton Boggs.
Good morning, I'm David Alexander from Squire Patton Boggs.
I'm Jacob Cummings, Squire Patton Boggs.
Can I just, I didn't hear you well. Can you repeat? Thank you. Thank you. Fine, I think we have everyone that we have on the list, and Mr. Fraser is the party representative, so he's admitted to the hearing before his testimony. We are here to hear oral argument, and then the witnesses and expert examination will follow the rules that are set in procedural order number 4, including the hearing schedule that's Annex A to that order. Some of the rules are also found in procedural order number 1. Over the entire hearing, each party has 14.5 hours, and that includes openings and the answers to the questions on of the tribunal on the last day. Today we'll start with the opening statements, 2.5 hours each. We have received the demonstrative exhibits, and if I'm not mistaken, we have already received the presentation by email from the claimants, which is to be sent before you start presenting. Tomorrow we'll start the witness examinations. As you know, this hearing is public in the sense that it will be posted, the audio-video recording will be posted on the ICSID website. So we should please make sure that the technician does stop the recording whenever we go off the record, because otherwise we have all kinds of break conversations that are recorded, and that is not good. And if you ever have to address a confidential matter, please raise it before you start so we can mark the recording and the transcript confidential. Is there any question, comments about how we proceed or any other topic on the claimant's part?
Nothing from the claimant's side.
On the respondent's part, no, none either. Fine, then I can give the floor for the opening argument to the claimants.
Thank you very much, Madam President, members of the Tribunal. In 2014, Discovery and its subsidiary AOG embarked on a project to explore for oil and gas in northeastern Slovakia. Discovery invested in Slovakia in reliance on exploration licenses that have been granted by the Slovak government under the Geology Act. The licenses and the Geology Act imposed an express obligation on AOG to design, investigate, and evaluate a geological task to explore for oil and gas within the concession areas. When Discovery invested in Slovakia, it legitimately expected that Slovakia would not prevent AOG from completing that task. But when the rubber hit the road from late 2015 onwards, and Discovery tried to drill its exploration wells, Slovakia prevented AOG from completing the task. Between late 2015 and early 2018, organs of the Slovak Republic made a series of decisions which ultimately caused the project to fail, and I'll refer to those decisions as the impugned measures. These measures are all attributable to Slovakia, and they place Slovakia in breach of its obligations to Discovery under the BIT. And now the impugned measures had significant consequences. They destroyed the commercial viability of the project. They caused Discovery's funders to stop funding the project. They caused Discovery's JV partners to withdraw, and they completely wiped out the value of Discovery's investment. Discovery therefore seeks an award of reparation to compensate it for the losses which it has suffered. So in my presentation this morning, I will be addressing topics 1 through to 5, and Mr. Newing will be addressing topic 6, quantum. I intend to spend most of my time on topic 2, taking the tribunal through the underlying documents relating to the impugned measures. In the interest of time, I will be skipping over some of my slides quite quickly, and I won't take the tribunal through the detail of every single document that's on the screen. But you have exhibit references in the presentation, as you will see shortly, and so the tribunal can go back, if it wishes, to certain documents in due course. So we begin with the background facts, and starting with the policy background. At the time's material to this dispute, Slovakia imported over 98% of its oil and gas from Russia, and that is undisputed. In 2013, Slovakia's import dependency, and hence the size of its energy trade deficit, was identified as a matter of concern by the European Commission. Successive Slovak governments had acknowledged the risks posed by Slovakia's near total dependence on Russian imports of hydrocarbons, and energy security was therefore a key pillar of Slovakia's energy policies. To this end, the policies acknowledged a desire by Slovakia to encourage domestic oil and gas exploration and extraction. The 2014 policy, which you will see on the slide here, said, quote, "The future of gas extraction efforts in Slovakia depends on the verification of new exploration concepts, ... that are financially intensive and associated with significant geological and technical risks. The feasibility of such projects fully depends on the clarity provided in geological and mining legislation and on the enforcement of exploration rights on the basis of this legislation." So that was the policy background against which Discovery invested in Slovakia. We now move to the legislative background, and I'll begin with the Geology Act on slide number 9. The purpose of the Geology Act was to encourage private companies to explore for oil and gas in Slovakia. That purpose is clear from various provisions of the Act, which I will take you to shortly. But the purpose is also clear from the Act's transposition into Slovak law of the European directive that I've quoted on this slide. Moreover, the former Minister of the Environment, Mr. Solomos, who you will be hearing as a witness in this arbitration, confirmed as much in an interview he gave in 2017. He was asked, why isn't prospecting done by the government? And his answer was, quote, the government has no money for this, and this is why it rents out exploration areas to firms and companies involved in such activities. In return, the government gets information about the state of the country's natural resources. Now, the Geology Act established 4 stages for any oil and gas exploration project. And in the following slides, I will briefly summarize the provisions relevant to each stage. These provisions we say are relevant and important for 2 reasons. First, because they provide the background to the exploration licenses and are relevant to the content of discovery's legitimate expectations. And second, because the provisions will put in context some of the terminology used in the parties' pleadings and in my oral presentation this morning. So we begin with stage 1, which is the grant of an exploration license. So looking at Articles 3C, Article 2.1 and Article 21, the geological work, and that's a key term, that AOG was carrying out in Slovakia was deposit geological exploration, 21.2a. Under Article 24.1, the ministry was responsible, that's the Ministry of Environment, was responsible for determining the areas in which exploration for oil and gas may be carried out. In order to carry out such work, it was necessary to apply to the ministry for the determination of an exploration area. And under Article 24.8, the exploration area was determined for the period required by the client and necessary for the performance of the geological works. And if that period specified was insufficient, the ministry could extend the period to enable the works to be completed. Article 24, subparagraph 10, confirmed that an exploration area could be awarded to a group of clients who jointly finance exploration works. And that was the position here because AOG, JKX, and Romgaz were jointly financing the works as JV partners. Article 24.11 provided that every holder of an exploration area shall hold the relevant exploration interest, which represents its share of the rights and obligations, and that's an important word, attributable to the holder of the exploration area under this Act and in the geological works. And in this case, the relevant exploration interests under the licenses were 50% AOG, 25% JKX, and 25% Romgaz. So that's stage 1. Stage 2 of the Geology Act relates to the design of a geological task. And this is another key term that is used throughout the Act and in the exploration licenses themselves. It is defined in Article